Jake Hill on behalf of Mr. Correll Brown. Correll, would you state your name?
Correll Brown.
Judge, like I said, I was just appointed, but again, we met last night for a significant period of time. I do have the discovery. He's seeking a preliminary exam in this matter.
All right. People have their witnesses available on the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
Thanks, Judge.
Your Honor, just confirming again for this record, since Mr. Brown requested a separate exam, that these are on the same.
I'm going to let Judge Barr decide whether or not the exams are held jointly or separate.
Okay.
If I put them both before him, he can make that decision. Thank you.
Thanks.
Court calls the case People versus Taylor Adams.
Good morning, Rob Jake on behalf of Mr. Hamilton. Judge, would you state your name for the record?
Kimani him.
Judge, I met with him last night. There's a lot of issues that we have to discuss. I'm asking for a brief adjournment.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m.
Let me see it.
On continued.
Thank you, Your Honor.
Court calls case People versus Abdul Rahman Al Deiti.
Testimony for people.
Mr. Court Defendant, reported on behalf of Mr. Al-Daiti, he's now approaching. Please state your name for the record.
Rahman al-Dai. Anti-pockets.
Go ahead. What are we doing?
At this time, Your Honor, we'll be setting this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 29th.
We'll try, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That is before Judge
Washington.
Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued.
State your name for the record.
Lamar Brasford.
Thank you.
Your Honor, at this time, we would like to waive over to circuit court.
All right. Sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts. Your turn.
We acknowledge the information and receipt of the information, and we waive its reading, and the client stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. As to all counts, pretrial will be set for
July 30th at 1:30 with Judge Conlon.
July 30th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Mr. Brumfield, will you state your name for the record?
Troy Brumfield.
Thank you.
Your Honor, Mr. Brumfield wishes to waive his preliminary exam today.
All right. Is that correct, sir?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Thank you. Your Honor, defense would acknowledge receipt of the information, waive reading, and my client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Hamid.
July 28, 2025, 1:30, Judge Hamoud. Bond will continue.
Thank you.
Just sign off. Court does call the case People versus Dominic Billing.
Unitary Attorney Kara Rosengren on behalf of Mr. Billings. Could you say your name for the court?
Dominic Billing.
All right.
Your Honor, Mr. Billings is going to waive his right to preliminary exam today.
All right. Sir, is that a correct statement?
That is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I do.
Understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Mr. Billing waives formal reading and stands mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 8th at 1:30 with Judge Moody.
September 8th, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Bond will continue. They're gonna need that. I didn't pull it out. Court does call the case of the people versus Robin Finney.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Finney, who's approaching. Ms. Finney, can you state your name for the court?
Yes, Robin Lee Finney.
Thank you.
Thank you.
And Your Honor, I apologize. I do have a green sheet. I am requesting an adjournment, a 2-week adjournment in this matter for continued discussion with the APA.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the people versus April Black.
Stephanie Cannon on behalf of the board. April Black.
Thank you.
And Your Honor, in this case, we are asking for a brief adjournment for mitigation purposes. My client has provided me some information. I need to provide that to the prosecutor's office.
Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. August 2nd. I'll call you. Oh, you want to address the cover? Your Honor, may I address bond? I'm so sorry. May I address?
He's out.
What?
Go ahead.
Oh, I didn't hear what you said, Your Honor. I'm so sorry. Your
I'm
Honor.
happy to change it.
Oh, he's out.
Go.
You're not going to change it?
No, I don't know what you're asking.
Oh, so Your Honor, my client is currently on tether. We're asking that the tether be removed. I have reviewed her file and the information in this case. She is charged with malicious destruction of property and resisting an officer. The police report itself is replete with information that has nothing to do with her resisting charge. It's my understanding, since then, she's been very cooperative with the police regarding the situation that pulled the police to the scene, which was a shooting. My client wasn't a part of the shooting. She was a victim of the shooting, her and her mother. In their haste to get away, the police did stop them. And my client has allegedly done some behaviors where she destroys a little bit of property, maybe we'll say, and she's going to pay for that. She understands that she has to pay for that, and she did resist. However, my client in that time frame was exceptionally emotionally distraught from the shooting. Her whole thing was to get away from the scene, to leave. And yet somehow, some way, my client, and again, she's done lineup, she's done everything the police have requested of her regarding that shooting. She has no other criminal history. She's not a threat to the public. She's come to every court appearance, and she will continue to come to every court appearance. We're asking that the GPS tether be removed, Your Honor. In addition, it won't allow her to go see her mom when her and her mom were trying to get away from the situation. And so she's also confused as to why the court is keeping her from interacting with her mom when her and her mom were victims trying to get away from the scene.
Response.
Yes, Your Honor, I did your arraignment on this, so that perhaps gives me a little bit more insight. So what happened here is, in my understanding, is there was not actually a shooting, it was an FA of Ms. Black's mother. And the reason that she has that color is that Ms. Black is accused of repeatedly trying to go to the home of the people she believed did that, which is just a few doors down from her mother. So there's no order that prevents contact with her mother. The order prevents contact with her mother because at the time this happened, Ms. Black was visiting her mother. And when the police responded, they actually used a lot of restraint with Ms. Black as far as they tried to just get her to calm down because they understood she was upset. She repeatedly told the police that she was going to the residence where the suspects were. And they kept telling her, no, you're not. And she kept telling them, yes, I am, and kept trying to walk over there. They had to physically stop her multiple times. Eventually, they ended up having her sit in the car, try to give her some time to calm down. When they let her leave from the car, she again said she was going there. And so, Your Honor, it was because she refused to calm down as far as going to that location, that there was that concern for safety. So there's no attempt to stop her from seeing her mother, and to keep her from going to that other location that's just a few houses down.
Your Honor, thanks, and I'm sorry, because she just finished. I'm so sorry. Please continue.
So that's why she had the tether There could not be a hot zone because Ms. Black lives so close to the location, and
Correct.
so to resolve that issue, it was a tether with a no-go, instead of a tether with a hot zone. So that's why there's that.
Gotcha. And I don't see an order prohibiting contact with the mother, so I don't know where that.
So she goes there, she takes her children there. This is somewhere that she used to go every single day because she takes her mother there. Now, we understand that she's not been charged for the felonious assault of anyone. She didn't go to those people's houses. She's not trying to go to those people's houses. She's calmed down a great
No, but the
deal.
allegation is that she tried to go there on that night, that she tried to go toward where these people were that committed the other alleged act.
Yes, Your Honor. So that is the situation. But my client doesn't want to go there. She's calmed down. She's never been there before. She has no intention of going to these people's house. It was just an emotional situation at that time. She's not that person, Your Honor. And she's asking for the court to give her the opportunity to show that that was a momentary lapse of judgment that she will not go back to.
Motion to modify bond is denied. Bond will continue. The GPS will continue.
Thank you, Your Honor.
ChatGPT G Noi, well, that took a turn. This hearing delivered a strong blend of procedural routine, some emotional undercurrents, and one particularly passionate bond modification request that stood out from the otherwise composed docket. Let's break it all down. We open with Carl Brown, who had just met with his newly appointed attorney the night prior. Despite the short notice, the defense came in organized and ready. Mr. Brown requested a separate preliminary exam and, though the cases were related, the judge left the decision to Judge Barr, who would preside over the scheduled hearing on July 29th. Everyone involved stayed on point, no grandstanding. No confusion, just a smooth, professional moment. Next up was Kimani Hill, appearing for Mr. Hamilton, who requested a short adjournment due to unresolved issues. This kind of brief pause is pretty common in early proceedings, and it was granted without fuss. Same story for Abdul Rahman Al. Didi, ready for a preliminary exam, discovery complete, and everything locked in for July 29th before Judge Washington. All business, no drama. Then we had a run of waivers, 3 in a row, in fact. Defendants Troy Brumfield, Dominic Billings, and another unnamed defendant all waived their preliminary exams and proceeded straight to circuit court. Each was advised of their rights, confirmed their understanding, and moved forward with not guilty, pleas, and scheduled pretrial dates. These cases were quick, clean, and marked by mutual respect between the bench and the attorneys. But the standout portion of this hearing was definitely the bond modification argument in the case of April Black. Assistant Public Defender Lavra Yagi came prepared, launching into a heartfelt and detailed request to lift Ms. Black's GPS tether. The situation, as described, had layers. Ms. Black and her mother were apparently victims in a tense, emotionally charged event. The defense acknowledged that Ms. Black resisted officers and damaged property while in distress, but emphasized her full cooperation since then, her consistent court appearances, and her lack of criminal history. Ms. Yagi's tone was firm yet sympathetic, clearly advocating for a second chance based on her client's present-day behavior rather than her reaction in a moment of crisis. The prosecution, however, calmly pushed back. According to their recounting, the tether was not just a precaution, it was essential, due to repeated attempts by Ms. Black to approach individuals connected to the incident despite multiple police warnings. The concern wasn't about her mother, but about the location's proximity to the other parties allegedly involved. The prosecutor explained that the GPS setup was a practical solution since a hot zone exclusion couldn't be applied. Both sides made reasonable points, but ultimately the judge wasn't swayed. The motion to modify the bond was denied, and the GPS order remained in place. The courtroom stayed respectful throughout, but you could feel the emotion in that bond argument. The defense wasn't being theatrical, just passionate. And the judge listened carefully before giving a firm, reasoned ruling. So, all in all, this hearing had a steady pulse with a flash of intensity. Nothing got out of hand, but it was a reminder that behind the legal procedures are real people with real emotions navigating tough moments. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.